Hi, Tom. Yeah, we're going to wait a couple more minutes to see if we get some folks on the call. I kind of had a feeling we might be a little shy today because of Thanksgiving, but looks like we've got more people joining us today. We're going to give it a couple more minutes, guys, so that we can get more people on the line here. Appreciate you all taking the time to join me today.
Absolutely.
I'm going to have to cut it a little short today, guys. I've got to be in the dentist chair this afternoon. Lucky me. All right, we're going to go ahead and get started, guys. Thank you all for joining me today. I wanted to talk to you guys about Earnest Money and what's going on. I'm dealing a lot of issues with Earnest Money. As you know, we're in a very tight market right now where there are, there's a ton of terminations on contracts. And so as your broker, I'm finding I'm dealing with a lot of issues where either the agent hasn't collected the earnest money in a timely manner, and or in one case right now in one of the market centers, we're dealing with an issue on an $8,000 earnest money. I don't think we even have it. So I want to talk to you a little bit about that issue today and let you know what the ramifications are and what the process is, because I get a lot of calls about the process of releasing earnest money if one of the parties won't sign the termination, and that happens a whole lot as well. So I think the best rule of thumb that I can tell you in this market that we're experiencing right now is that you need to be very cognizant of collecting that earnest money up front when you go under contract with either a buyer or a seller, especially if it's your seller. That's their liquidated damages. And if and I've seen this over and over again, where the due diligence period is for 5 days and they're going to collect the earnest money within 3 days, and the earnest money isn't collected, the due diligence expires, and we have no money to send to the seller. So I think out of this conversation, I'd like to hear from you guys as well, what you're experiencing, that we really need to be collecting earnest money with our contracts, not giving it, 3 days to collect earnest money. Really take a look at your timelines. And what happens is once a contract is terminated and we actually have the earnest money, then if we can't get one of the parties to sign the termination, then we have to do what we call a 10-day letter. And I've got a standardized form for the Heart of Atlanta group. So if you ever get in a situation where you need a 10-day letter, you need to get in touch with me so I can email you that. It's the information that we need in order to process the letter. Eileen Smith, who's an associate broker out of the Decatur office, writes my 10-day letters for me. And she's very, very good, and she's by the book. She's ex-military, and she really goes with, pays attention to what that contract says. So as agents, it's your responsibility to make sure this is other people's money. And so we want to make sure that we are asking for that 10-day letter in a timely fashion, if in fact it needs to go out. But more importantly, I think you guys have got to be very cognizant about collecting earnest money up front when you're writing contracts, especially if you're representing a seller, since that's their liquidated damages. We need to make sure that that earnest money is collected and deposited in a timely fashion according to the contract. So are there any questions about that so far?
Yes, Tom, I have a question.
Hey, Sharon.
Hi, how you doing?
I'm good. How are you?
Great, thanks. The 10-day letter, who is that sent to, and what does it say basically?
Okay, that's a great question. So what the contract says, if the parties can't agree to the disbursement of the earnest money, the holder of the funds has the right to disperse the funds to the party based on a reasonable interpretation of the contract. So if I'm the holder I'm going to make sure that we review all aspects of the contract, and we're going to disperse those funds accordingly. Now, here's the challenge that we have had with a closing attorney holding earnest money funds. They don't like to, they're not governed by the Georgia Real Estate Commission the way we as licensees are. So I've seen closing attorneys just give the buyer back their money without any documentation, letter, anything. I've seen them interplead it when in fact it is a clear-cut case as to who should receive it. And I've also seen them read much more into the circumstances around the situation than just reading the contract and making a determination based on what the contract says. I've experienced all of these things. So if you are an agent and you're representing a buyer or a seller and you allow that closing attorney to hold earnest money funds, then you may be risking their ability to collect those funds if it turns into an issue. Those are just my experiences that I've experienced with closing attorneys holding funds. Sharon, does that answer your question?
Yes, yes, thank you. Mhm.
The other option is to interplead the funds. If we can't come up with a reasonable interpretation, we have the right to interplead the funds and let the courts decide who the money should go to. I, in 24 years, have never had to do that. I almost had to do it one time, and the attorneys got involved. And I said, okay, Mr. Attorneys, I have the right, and this is also in the contract, to withhold out of that earnest money my reasonable attorney fees and costs associated with interpleading the funds. And you all can go to court and fight over $1,000. How about that?
What does
And
interpleading mean?
they agreed to split it. I'm sorry, what was your question?
Interpleading, I don't understand. I'm sorry.
Interpleading is, okay, so when we're holding earnest money, we have three options if there's a dispute over who it goes to, right?
Mhm.
We either have a signed termination where the parties have said, yeah, the buyer should get their funds or the seller should get their funds. We have option two, which is the holder of the funds can disperse funds based on a reasonable interpretation of the contract.
Mhm.
Okay. And the third option is to interplead the funds in a court of law and let the judge decide who would get it if we can't come up with a reasonable interpretation. And like I said, I've been doing this for a long time. I've never had to interplead funds. It's usually you could, the contract will tell you who's defaulting, generally speaking. That answer your question?
Thank you.
Now, the other thing that you all need to understand with earnest money is that if I am the holder of the earnest money and I find out that it hasn't been received, I have to notify the buyer who hasn't turned in the earnest money and the seller and notify them that we haven't received the funds. The buyer has 3 banking days at that point to make good and deliver the funds. And if they don't deliver the funds, then on the 4th day, the seller can terminate the contract. Or they can move forward with the contract with no earnest money. But I've never seen that happen. Why would a seller move forward with no earnest money if the buyer hasn't even submitted the funds? That's kind of a waste of his time.
Sorry, I have a question. Okay, so when it states 3 days after binding, or let's say I put 3 days after binding, and on the 4th day, it's not submitted, there's another 3 days that before the contract is terminated?
Once on that 4th day, if they haven't, then we need to notify them that they're in breach. They have 3 banking days from that notification to deliver the funds. And if they don't, then 4 days later, 4 banking days later, the seller can terminate the contract.
Is there a time, is it like the due diligence, like, okay, on the 6th, the earnest money was due. So let's say they contacted you on the 6th and said it's due. So then it would be the 7th, 8th, and 9th full day?
If they're banking days.
Yeah,
So if your earnest money is supposed to be delivered on Friday, then more than likely that notification won't go out until Monday. We're not in the office on Saturday and Sunday, but you as a licensee have the right to send that notification to the other party and let them know they're in breach. And then, but that Saturday and Sunday are not going to count as days because they're not banking days. So that buyer, let's just say we notified them on Saturday that they're in breach of contract because their earnest money was due Friday, then they would have Monday, Tuesday, Wednesday to deliver the funds. And then if they don't, then on that Thursday, the seller can terminate the contract.
thank you.
Tom, I have a question. This is Chris.
Hey, Chris.
Hey, so with that being said, if the seller opt to just cancel the contract, can they also call for the earnest money to still be given to them or no?
Yes, they can. They would have to they would have to file they'd have to go to court to collect that because we obviously don't have it. So
Okay,
we have
thank
nothing to disperse. So, but they can go after that buyer in small claims court, depending on how much the earnest money is, and try and collect it that way.
Okay, thank you.
You're welcome.
And Tom, this is Barbara, and the only thing I just want to reiterate at this point is that all of this definitely needs to be done in writing.
It all has to be done in writing, correct? Your best, the best form that we have that is the most underused is the notice, the GAR form notice form. That form should be what you use whenever you're sending any kind of official notification to the other party. We live in a world where people send emails and texts, and text is definitely not a form of delivery of notice. Email is, but you're better off sending notification form so that it's in writing on a piece of paper that can be added to your file if there's ever an investigation by the real estate commission.
Where's the 3 days after? Where is that in the contract?
It's in the paragraph that under earnest money,
Okay,
page 2, under earnest money. All this is there for your reading pleasure. I would, if I were you guys, I would read that very, very carefully, because I don't think that we do a great job of protecting other people's money. And I don't think we as professionals do a great job of making sure that we understand the ramifications of earnest money and the failure of delivery. That's why I harp on this constantly. I know you all get tired of it, but it's the number one issue that I deal with in all 6 offices. And quite frankly, if you as a licensee, if you don't notify the other party that they're in breach, and at some point we get a letter like we got last week from one of the offices from a broker looking to collect the seller's earnest money, and we don't have the $8,000, guess who's going to have to pay that? The brokerage. And I'm sure that's going to trickle down to your office bill. So the quickest way to real estate jail for any licensee is the misuse and mishandling of other people's money. You'll get in trouble quicker by that than anything else we do in real estate. All right, who else has a question? Are you all clear now? All five of you on the call. Are you all clear about this process? Because I want to make sure that you all are the best in the business when it comes to this kind of knowledge. Because quite frankly, I get calls from brokers who don't even understand this half the time.
Yes, and I would say maybe also if the attorney's going to be holding the earnest money, to make sure that they sign and agree to hold the earnest money also.
That's right. I get more contracts that come in, and we've got the F510, which says the closing attorney is the holder of the funds, but we don't have the F511, which is the agreement that they agree to hold it and sign off on it. Those two are required, and it says it at the top of the form. You can't have one without the other. And I will tell you that I have had attorneys play that card and release earnest money to the wrong person because they said they never agreed to hold it. And we didn't have an F511. So that's a very good point, Stephanie. Any other questions about earnest money? Now's your time. Any other questions, guys?
I do have a question. I have an email into you, so I guess, I mean, it's an odd situation. So do you want me to ask it in class?
Yeah, sure.
Okay, because actually I've talked to agents that have been doing it for 30 years and they did not know what you told me about. Okay, so the goal is, you know, that the buyer really wants to terminate. We're past the due diligence. And I said, hold out before you terminate. Let's see if we get a low appraisal. Sure enough, we did. It's $3,000 too low. And so we're still in the appraisal contingency. Tom said, that we can't immediately, that was the question, was, could I immediately send the termination? No, you said we need to ask for the money. They need to deny it. Well, and actually I had two agents tell me, differently, but anyway.
You always have to ask, you always have to present the amendment to reduce sales price. It says that right in that paragraph. And if you don't, you're not really giving the seller the opportunity to lower the price. We have to give them that opportunity.
Well,
I've seen people lose their earnest money over that by not sending that amendment to reduce the sales price.
Okay, so based on that, what you said is, so I sent it and I received a response from the seller that says, hey, I will pay the $3,000 difference if we reduce the closing costs, because he's paying $6,000 to $3,000. And I wrote back, we're not renegotiating the closing costs. That's already in the contract. Do you want to pay the $3,000 or not? Because ideally I want him to say no. Can I take that last answer that he had as him trying to negotiate as a no, or do I need to wait on him to respond to my question of, we're not renegotiating the closing costs. Do you want to pay the $3,000 on the sale amendment or not?
You need to give them the opportunity to respond.
Okay, if I wouldn't have said that, if I wouldn't have asked him that, could I have just used the termination at that time when he was trying to negotiate on the closing costs as a no?
I think what you did was correct. And I think that they owe you an answer. And if they say, no, we're going to reduce the closing costs, then you, at that point, you can terminate the contract.
How much notice do I have to give him from his is it from the receipt of his response?
You need to take a look at that paragraph under the appraisal section, and it will tell you what the timelines are.
But he's already responded. I mean,
Then you have, if they responded and they didn't respond, and you've asked them about closing costs and they haven't answered you, then we need to get that answer.
but when does the time frame start? When
They
he-
have three days, I believe is what it says.
from the time that he last answered me, or from the time I sent the
From the time
amendment?
that you sent the amendment to reduce the sales price.
Okay, thank you.
Barbara, did you have your hand up?
I did have my hand up, Tom, in regards to that time frame that she was just asking about, but you did answer it. Because I just really wanted to point out to her that she can't let this linger. There are time frames, like you said in that paragraph, she cannot let this linger forever. And
Right,
if you,
that's right.
I know, Tom. And so if you get outside of that time period, is when you start jeopardizing that earnest money, as Tom was saying. That's what I just wanted to say, Tom. Thanks.
So wait, when is, so I can't let it get past 3 days? I thought I have to give it 3 days. I'm sorry, I'm confused.
No, you don't have to give it 3 days. Once they respond, if they say, no, we're not going to reduce the sales price, then you all can, at that point, terminate the contract.
Let's say he does not respond, and I sent the termination amendment yesterday morning, and he responded yesterday at 5 p.m. that he wanted to negotiate on the closing costs. When would the 3 days, so the 3 days from the amendment would be 3 days from that morning, but let's say he doesn't respond. She was talking about if I wait too long.
It will tell you in that paragraph when you can terminate. Once they respond,
3 days.
yeah, then you can go ahead and terminate if you all don't agree, can't agree on this, on the price. But trying to negotiate closing costs on top of that is not really reducing the price.
Right, but she was saying that there was a time frame that it was too long. If you wait 4 days or 3.5 days, when is the expiration after quote unquote 3 days? That's too long where you would lose.
I think it's, I don't have that document in front of me. That's why I wanted you to take a look at the appraisal piece of it on that form and read.
Okay.
It will tell you what the dates are. It'll tell you the timelines.
Okay.
Does anybody else know those timelines off the top of their head?
Yeah, Tom, I do. Those
Okay, Barbara.
Okay, the timeline is when you get that appraisal from the appraisal company and you get that sent over to that seller as expeditious as possible. You want to get that to the seller because the seller does have 3 days to respond back to you, whether they're going to accept the reduced price or not. And then based on that, the buyer also has an additional 3 days that they can respond back also. But like Tom said, the loopholes are in that contract and they are in that particular paragraph to tell you exactly what to do. So it's really 3 days and an additional 3 days. But like Tom also said, you don't have to wait the full 3 days. If that seller responds back to you within a day and a half, then you can respond back for your buyer.
Right, that's
the other
right.
week that she's interested in.
What?
Joel, you've got your hand up.
The only.
Okay,
the-
I'm trying to
the listing.
kind of understand it too. So
Somebody
they've
needs
got
to
3
mute.
days. They've got 3 days to figure out if they want to let the seller know. And then they have 3 days for the seller to decide if they want to move forward.
And that's.
But they have to make sure, because if they don't do it, if the agent doesn't do the termination, then it's assumed that the buyer wants to continue. So my
That's-
question is,
that's
can she
correct.
just can, it almost seems like she has the ability to terminate now versus waiting, multiple days, because if the person doesn't respond back and you don't, if you don't say anything prior to a send a termination, then it's assumed that the buyer wants to continue.
But when you send over the sale price, when you send over the amendment to reduce the sale price, that seller has 3 days to respond. So say today is Monday, the 21st. If you get the appraisal back today and it says that the appraisal came in low, you need to send that appraisal,
Okay.
an amendment to the sale price. You need to send that over to that seller today.
So let me look.
Somebody
So I'm
needs to
assuming
do
she's
that.
done that already.
I've done it and he's responded.
Okay, so from that point, the buyer has 3 days to
But,
respond. So when those
that's
3
where she
days, you
would like
guys need to
stay, and
decide.
that's what she's willing to pay, then,
Is that-
definitely all depends on the
Is
client.
there somebody on our call? So that once that seller responds back, that buyer has 3 days to respond too. So whatever you guys are gonna do, it needs to be done in that time period, because like Joe just said, if you don't respond, then you just implied that your buyer is gonna move forward and pay the difference on that appraisal amount.
I did respond. I said, we're not negotiating the closing costs. And I asked him, do you want to reduce the sale price or not? So when can I send the termination? 3 days from the first, Tom said 3 days from when I
3
originally
days
sent.
from when you said, do you want to reduce the sales price? We're not negotiating the closing costs.
But not sooner.
Not sooner. He has 3 days to respond.
The seller has 3 days to respond.
From the last comment, not from when I sent the amendment to change the purchase price, right?
Should it be from when she sent the actual written document saying that she wants to change the sales price?
I thought that was when I could terminate. 3 days from the time I sent the amendment is what I thought. But you're saying 3 days from the time where he replied.
I think in this case, I would consider that email from him about negotiating closing costs as a counteroffer.
Okay, and being said that, what?
So 3 days. When was that? On Saturday that you sent?
No, that was last night at 5 PM.
Okay, then Monday, Tuesday, at the end of the day, Wednesday, you can terminate the contract.
5 PM?
Yep.
Okay, thank you. Okay, let me ask you this. What if he responds again, trying to negotiate? Do I have to wait another 3 days for me to terminate from his last response?
No, because you ask him to reduce the price by $3,000. So if he agrees to reduce the price by $3,000 and all other items remain the same, then you can terminate the contract.
And I
No,
have a
but if-
question. I just want, is this a FHA conventional VA? What kind of loan is this?
Conventional. But if he responds trying to negotiate, like, okay, I'll pay $1,500 and you pay so I get a response from him, let's say tomorrow. Do I have to wait another 3 days from that last response? If he's trying to
The
counter.
answer
that?
is no.
Yeah.
You do not. The question is, are you going to reduce the price by $3,000? Here's the appraisal. And if they don't, then from 3 days after that, you can terminate the contract.
No.
But that was what the amendment was for. I asked him that and he's trying to negotiate. So then you said I had to wait 3 days from his last counter. What if he counters again?
I said, I think that you're in it. I think he is trying to, what he has sent you is a counteroffer. But that still doesn't mean that you haven't, that he's agreed to reduce the sales price by $3,000 and not change the other terms of the contract.
Well, let's say he counters and says, I'll pay 1,500. Then I take that as a no.
That's a no.
Okay.
Tom,
Joel,
can I
you have a question?
Yeah, because I'm gonna be honest, I'm a little confused because I'm looking at it like this. If the young lady, Karina, sent over, she got an appraisal on Friday. She sent over an amendment to reduce the sales price. And that was, she did that on Friday. And then the seller gets back to her
Saturday
on
morning,
Sunday and
Saturday
says
morning.
that, I'm just gonna use it as an example. Comes back on Sunday and says, or Saturday, and says that, well, I don't want to do that. I want to reduce the closing costs. And to me, that's a no. So,
I would agree with that.
and so the person has, I would say, 3 days to change his mind from Friday, which would be Saturday, Sunday, Monday, end of day. And if he didn't respond, to what the buyer wants, then you should be able to terminate.
That's correct. That's what we
Okay,
keep
Tom.
talking about.
No,
Tom, I
Tom,
want to
you-
read this paragraph. I want to read this paragraph from the conventional financing exhibit. I pulled it up for you, okay? So I'm going to read it. This is what it says. It looks like we lost Tom. Oh,
No, I'm here.
okay. What it says under the appraisal contingency for the conventional financing exhibit in paragraph number 2, it says the seller shall not later than 3 days from the date of the amendment to reduce the sale price is delivered to the seller, but not later than 2 days prior to closing, shall accept or reject the amendment to the sale price, or seek to negotiate with buyer a lesser reduction in the sale price of the property that what is reflected in the amendment to the amendment to reduce the sale price. If within the above time frame, the amendment to reduce the sale price has not been signed and accepted by the buyer and the seller and timely delivered to create a legally enforceable amendment, buyer shall have an additional 3 days, but not later than 1 day prior to closing, to terminate this agreement without penalty. If the buyer does not terminate the agreement within this time frame, buyer's right to terminate due to the failure to agree to amendment to the sale price shall be waived, and the buyer shall close on the property for the purchase price set forth in this agreement. Nothing herein shall require buyer to seek a reduction in the sale price of the property if you get outside that time frame.
I still am confused about, I gave him this purchase, the amendment to the sale contract Saturday morning. He responded Saturday evening at 5 p.m. that he wanted to negotiate. So is it 3 days from the negotiation counter, or is it 3 days from the purchase amendment of the purchase amendment?
It is 3 days from the date you sent over that amendment to reduce the sale price, and you said you sent that over on Saturday. He already responded back to you. So again, you need to see if it's going to be accepted or rejected.
But he responded back, so, but how much
did.
longer?
Have
He
you called
responded.
him? You
He
might just want to
responded in
call
his
him.
3 days.
3
But
days
you-
from the time that I sent the amendment.
He responded to you within those 3 days. And like the young lady, I think Megan was just saying, have you talked to him or his we'll talk to his agent, really.
Yeah,
No,
I
I-
would have a conversation with him and knock.
I'm
these-
not talking to him. I'm talking through the agent. She keeps forwarding me his emails, and I'm just responding to both of them.
Well, here's the thing, guys. The bottom line is if he hasn't signed that amendment to reduce the sales price within
That's
3
right.
days, then you can terminate.
Right.
So he gave it to, you sent it to him on Saturday.
Saturday morning.
So that's Sunday, Monday, Tuesday. I was off a day earlier. Tuesday.
Tuesday morning, Tuesday evening, does it matter? Is it 3 days from, because the Saturday count not being a business day? Or does it?
It doesn't say business days.
Okay, 3 days from the time that I sent it, I can terminate if he has not accepted it,
Correct,
regardless of the fact that he has tried to counter with me.
correct.
Can I ask a question? This is just a hypothetical question. I understand, sounds like the buyer just wanted to terminate.
Yes,
Period.
absolutely. Yes.
Right. So Tom, my hypothetical question is, if the seller opts and say, okay, I give the $3,000 cut in sales price and I go ahead and give the closing cost, what leg would the buyer have then to terminate? Because the seller is
They don't.
agreeing.
They
No,
can't
Okay.
terminate.
Yeah. We know
So
that. Yeah.
Okay. I was just asking.
Can I ask a question, please?
Yes. Hey, Tammy.
Hey, so I think part of the confusion was in Karina's response, instead of just saying no at them wanting to negotiate, right? She could have said no at that time and then that would have ended it. Didn't you say you asked another question? Can you do this or that?
No,
So
I
that
said,
was-
I'm not accepting your closing cost negotiation. We're
Uh-huh.
not negotiating closing costs. That's in the contract. I said, do you, I asked him twice in the amendment as well as in the email. I said, do you accept our reduction in sales price by 3,000 or not? That's it. So I double asked him. I mean, it was the same question that was in the amendment.
Okay, I guess at that time when they said they were offering that, the answer would have been no, we don't accept it, and you could.
I should have said no. Yes.
Yeah, okay. All right,
And at that time, I should have said no and sent the termination.
mm-hmm.
Is that right, Tom? I could have done that? When
If
he,
the sellers-
countered?
If he said no, I always like to caution and use the timelines and make sure that they don't change their mind within 3 days. Because if he hasn't signed off on it and he's still trying to negotiate, there's a chance that he might go ahead and sign off on it anyway. So it's just like you can't terminate a contract the day before closing because the buyer said they're not going to close. You have to give them the right to close if they want to close. So this is the same situation. You have to give him 3 days to sign off on it. And then if not, and I would just say to the agent, if he doesn't sign this amendment to reduce the sales price, we're gonna terminate. And maybe, I know your buyer doesn't want to move forward, but I mean, this is where they're at in this contract. Joel?
Sorry, I meant the little man.
Okay, I didn't know if you had another question. Anybody else have anything they want to discuss? Guys, it's very, very important that you read these contracts, paragraphs, and understand what they say. Okay?
What was Chris's question?
What's that?
I don't know. Chris had a question in the chat.
Yeah, I just said, if you just sent over the TNR and everybody signed off, it's a done deal. All the waiting game is over. Could that be done?
You can't do that if you are asking for a price. You have to ask for the price reduction. You have to give the seller the opportunity to reduce. If you don't do that, you will lose your earnest money. So you can't just terminate the contract without, you always have to ask for the price reduction.
I'm saying, like, if it's been 3 days, then you can just send it over. And then if everybody sign
Yeah,
off.
it hasn't been 3 days yet, but when the third day comes
Right.
and goes, send over the termination and get it signed off on.
Okay, all right, yeah, that was my question.
Okay.
Hey, Tom, Yolanda, how you doing?
Hey, Yolanda.
Hey, so this is really a great topic considering that this is going on in a sense with me, but all the T's are crossed and all the I's are dotted, so we'll be fine. But this is more of a statement, maybe a question. If my client totally qualifies, however, she's just going back and forth because she's nervous about the payment. And then of course she's good 1 minute, the next minute she's not. And then finally she's not good. She terminates at the 9th hour, 12th hour, however you, and although she's still in the financial contingency, she absolutely does qualify. So the lender was absolutely refused to give her a letter stating she does not qualify. So therefore, she lose her earnest money. And so I was explaining to her that because you qualify, he will not send that letter. The seller is fighting for your earnest money. And her thing is, but I'm still in financial contingency. So I had to go back and forth with that thing. And that's really the situation that's on the table now. Although it's not a fight and it's going to be okay. I wish that there was a way that she, because being in the financial contingency, just still being in it, and even though she did not agree with other payments, just because she's still in a financial contingency, there was a way for her to get some of her earnest money back.
Yeah, unfortunately, that's not the way our contracts are structured.
That is correct.
They're not structured to allow people to get out of the contract because they change their mind.
That is correct. And that was my explanation to her. And this is the reason for the fight and for her being so upset. But she gets it. She gets it now. And then my last question is, with this earnest, that we use the earnest electronically submitting the earnest money. So this particular client decides that she's just going to, she's already made, her earnest money payment in a timely manner. However, she decided to stop payment. So is there not, and now she says, I'm sorry, I'm going to make the payment. Is there a way that Earnest, the electronic folks that we use, do they then allow them to resubmit some kind of way, or how does that work? Because that's the question on the email today, actually. How does that work when she says, no, okay, Yolanda, you're right, I apologize, I'm paying it, I shouldn't have stopped payment. Is Earnest now going to go back and allow her to resubmit?
Well, as far as I know, the earnest, once they collect it, they eat it. If your buyer did what we've got the money, but she may want to make them whole.
Mm-hmm. Mm. Oh, you got the money even though she stopped payment?
That's what I understood from Kadar.
Yeah, that's what I thought. Okay, cool. Well, then it's all going to work out fine. I just thought that if she stopped payment, since you all got that letter, since we all received an email indicating, hey, this buyer's funds are not there, I thought that they weren't there. And she did this a long time ago, so I didn't see a reason why the payment wouldn't have been there.
That's a question that I think Kadar has the answer to that. I think what he told me was that we had the funds and that that Earnest was going to have to eat it if they couldn't collect it from the buyer.
Oh, I see. I get that. That makes sense. Okay, well, all is well because she's paying it. Thank you, Tom. I appreciate it.
Okay. All right, guys, I've got to go to the dentist. I appreciate you all. Hopefully this was helpful. And we got a lot of good dialogue in today, and we will see you guys in December.
Hey, Tom, can I ask a question? And
yes,
I think
ma'am.
I brought this up at our last broker strategy call. Hopefully we can take each one of the financing contingencies and use those as a subject in our broker strategy call, maybe if not before the end of the year, but maybe starting in January.
I think based on this call today, that's a excellent idea.
Thank you, Tom.
All right.
I'll help you.
I appreciate it.
Thank you.
All right, guys. Thanks. Have a great Thanksgiving. Appreciate you being here.
Thank you.
Thank you. Happy
Thank you.
Thanksgiving to you. Hey,
Well.
Stephanie.
Happy Thanksgiving.
Okay.